If you were representing Trump in this, what's the first thing you would do?
First thing is I move for a change of venue out of the single district in the United States that has the most anti-Trump voters. That's number one. Number two, I move for the recusal of the judge who worked for a law firm that has had a history of corruption and conflicts of interest. And she herself was in the law firm when it represented Hunter Biden in Burisma. So those are the first things I do. Then I move for a dismissal of aspects of the indictment that clearly impinge on both the First Amendment and the Sixth Amendment. This is a very defensible case, but it has to be defended in front of a jury of Trump's peers, not a jury in which 90-something% of the jury veneer probably voted against him, and very, very, very few support him. So it's going to be uphill in the trial court if it stays in the District of Columbia, but then there's an appellate court, and then there's ultimately the Supreme Court. The biggest case that's going to help him, interestingly enough, is New York Times versus Sullivan. New York Times versus Sullivan, I was a law clerk when that case was decided, basically says the First Amendment protects lies, mistakes, errors. You have to show that there was actual malice. The New York Times printed an ad which was mistaken. And many, many people have been defamed, and yet the courts have said, no, you have to prove actual malice. And a fortiori, if you have to do that in a civil case, in a criminal case where it's proof beyond a reasonable doubt, the prosecution is going to have to prove that Trump had this Hamlet moment. To be or not to be, I am now stepping over the line and becoming a fraud. I'm now saying that I believe the election was stolen when I know full well that it was a fair and valid election. They're not going to be able to prove that.
I want to play you a Bill Barr soundbite on free speech in 1 second, but the odds of Trump taking the stand in any of these cases are very slim. So how do they get to state of mind? In this case, the prosecutor Jack Smith will put on evidence. In the indictment, he lists all the people who told Trump, you lost. We haven't been able to find any meaningful evidence of voter fraud. You lost, you lost, you lost. And Trump's defense seems to be, it's multifold, but one of them is, I didn't believe you. I believed my lawyers. I believed Sidney Powell. I believed Rudy Giuliani. I believed all these other people who said, actually, we're seeing real evidence for fraud and we don't trust the system and everybody's out to get you. You can't trust those guys. They're deep state. But Trump's probably not going to take this stand. So how does he get that in?
That's a very good question. If I were the defense, I would stipulate to the fact that he was told by many people that he had lost the election, including his own son-in-law. But then I would put on witness after witness after witness, starting with Jared Kushner, but going to many, many people who interviewed him and who will testify that he said over and over and over again that despite the overwhelming evidence that he was wrong, and he was wrong, I don't agree with him, he was wrong, he actually believed that he was correct. He actually believed the election was stolen. And I've spoken to a lot of people who have interviewed him and who know him well. I'm not one of them. I just only met him a few times. I did defend him, obviously, against the first impeachment, but I'm not somebody who has given him legal advice beyond that. But people who have, and people who have interviewed him, all say he really believes this. Now, some people call it the naivete or self-serving defense. He talked himself into it. He persuaded himself that he actually won the election. But that doesn't really matter as a question of law. The real issue in the case is going to be the instruction the judge gives. We'll get to the judge in a minute because she is the worst possible judge to be sitting on this case when you need to have not only the reality of justice, but the appearance of justice. But if I'm the defense, I ask for an instruction that says, ladies and gentlemen of the jury, you must conclude beyond a reasonable doubt that Donald Trump himself actually believed that he had lost the election and he was intentionally defrauding the public. The government will say, no, we need an instruction that says he should have believed, a reasonable person would have believed. And that's going to be the key on appeal as well when a case gets to the Court of Appeals and the Supreme Court. Which instruction is the proper one? And the Supreme Court has been moving more and more toward requiring individual specific knowledge of the wrongness, not the reasonable person test in the context of a criminal case.
Good. The Supreme Court siding on with the First Amendment and a wide berth for people to say wrong things or things that they know are not true. It's
Right.
not a nice thing to do, but it may change your opinion of the person, but it doesn't make you a criminal.
It's
I
a
actually
reason to
mentioned this
vote against.
yesterday with Andy
Yeah.
McCarthy, where I was saying if you were to bring a defamation case against somebody saying they said something false about you, you'd have to prove that they knew it was false or that they recklessly disregarded the truth. And we were debating, like, do we think the reckless disregard of the truth standard could be used against Trump? And I think both of us edged on probably not in a criminal case. That's not going to be enough.
I wish I had been on that conversation. I agree with you. Probably not enough. It wouldn't surprise me if the court did say the same standard applies. Remember that this standard is now being challenged, including by me. You may remember that I'm suing CNN because they doctored a tape. They had me say exactly the opposite of what I said. And the judge found that I had been defamed. The judge found that they knew that I hadn't said that. I had said nothing of the sort. But the judge said, well, malice, you have to prove that by clear and convincing evidence. And he found that I hadn't proved it by clear and convincing evidence. That case is now on appeal. And we are also challenging the notion that the plaintiff, the man defamed or the woman defamed, has to prove by clear and convincing evidence that the people knew it. The judge in my case found that they were stupid, they were ridiculous, they should have known, they were irresponsible, but he couldn't get over that line.
This summer, big box retailers are seeking a massive big government handout from Congress, paid for by consumers, smaller financial institutions, community banks, and local credit unions. That's according to the Electronics Payment Coalition, a sponsor of today's episode. It's called the Credit Card Competition Act, aka the Big Box Bill. Mega retailers are in favor of it, but the Electronics Payments Coalition is not. They say this big box bill would actually transfer billions from consumers to retailers through eliminating popular credit card rewards programs, weakening cybersecurity protections, and reducing overall access to credit for people who need it the most. You can visit stopthebigboxbaitandswitch.com to learn more. That's stopthebigboxbaitandswitch.com. The link is in the description. Learn more, and if you want to help them, tell your legislator to stand up to the retail giants and to support consumers and small businesses. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.